Okay, good afternoon and welcome to everyone who is joining this event of today, Bridging the Gap, Cooperation and Coordination Across the EU-AI Governance Actors. My name is Florina Pop and I am the data protection expert here at EIPA, which is short for the European Institute of Public Administration. And I will be opening this event, which is part of a series of online events that we have here at EIPA under the umbrella of EIPA in Conversation With. Now, for those of you who are joining us today for the first time and who are not very familiar with what EIPA is doing, I would like to add now a few words on that. And then I will also highlight why is EIPA actually organizing this event. EIPA was established in Maastricht in the Netherlands more than 40 years ago with a very clear mission, actually, to provide in-depth insights and practical knowledge about EU policy and EU law to professionals which are involved in the European public affairs. So we are speaking here about EU civil servants, but also public administration in the member states, and also candidate countries. And how are we doing that? Through high quality training, through applied research, and also consultancy services. So I would say that in this sense, EIPA is uniquely positioned at the intersection of policy, law, public administration, and practice, offering expertise that bridges theory and real-world implementation. And EIPA is supported also by the national administration of EU member states and also by the European Commission, and it regularly collaborates with EU institutions, national governments, and regional authorities to basically keep its mission to strengthen administrative capacity and effective governance across Europe. Now, about the topic of today and why we have this webinar today is that EIPA's direct link to the subject, cooperation and coordination in EU AI governance, lies in its long-standing role as a facilitator of knowledge exchange and also capacity building on complex cross-cutting EU policy and EU law issues. And as the EU is implementing the AI Act, which is the big topic of today, and develops new governance structures, EIPA's experience in fostering dialogue, in sharing best practices, and supporting the practical application of EU law makes it, we say, an ideal organizer for this panel, and we are proud to say that. So as I said, as the European Union enters the critical phase of implementing the AI Act, the effectiveness of this ambitious regulatory framework, and the first of its kind, and again, I have to say that we are proud of that, will depend on how well a diverse array of authorities and stakeholders can work together. So this effective coordination is both a challenge, as we, those working in the data protection field for some time already know, but it is also a necessity for the successful implementation. And I mentioned this because obviously my expertise is data protection, and because EIPA has been at the forefront of this topic, of this field of law since back when it was still considered a niche, back in 2014 when we developed our first data protection certification course. But I also say this because what all our distinguished speakers today that I will introduce later on have in common, and it's not a coincidence, is a deep expertise rooted in data protection and data protection authorities. And I think this is hardly surprising, given that the ongoing conversation around the AI and AI Act is strongly shaped by data protection specialists, whose insights are essential actually for ensuring responsible and rights-based governance of AI. Now, the member states have already highlighted the importance of establishing robust national governance structures that foster cooperation between responsible authorities, especially where AI systems process also personal data. And obviously, I would say while this field of law is important, so data protection and privacy, there are other aspects that I would say are essential for implementation of AI and coordination between the AI governance actors. And most certainly the exchange of good practices, what we are trying to do also with this webinar, and the development of joint guidelines that the representative of this organization that are joining us today are doing on a daily basis, are essential for achieving a common understanding of the implementation of AI and how to coordinate this work. Now, our discussion of today will focus on designing cooperation so that the decisions that are taken are consistent, the synergies between the different stakeholders and authorities are maximized, and contradictions are hopefully avoided. Achieving this level of coordination requires not only significant technical expertise, so AI literacy, in addition to the data protection field that I was mentioning, obviously, but also sufficient resources and funding. And this is why the webinar of today is structured into 3 segments, and each addressing a key aspect of EU AI governance. The first segment is about defining roles and responsibilities. The second one is about overcoming challenges in oversight and enforcement. And the third one, strengthening cooperation and fostering effective communication. Each segment of our panel will feature 3 focus questions, one for each panelist, in order to provide expert insight and set the stage for a broader discussion, which hopefully we will have also at the end of this segment 3, also with the audience that is joining us. So we have a limited time and a structured panel, and I would very much appreciate if the speakers that we invited today would allocate around or a maximum of 5 minutes to each of their responses, so that after this question and responses, as I said, at the end of the webinar, we will also have the chance to open the floor for the audience. So the question and answer session is scheduled at the end after the 3rd segment, and hopefully those of you joining will get the chance to get your question answered. Now, since we want to give already an example of cooperation and coordination here at EIPA, I'm not the only representative of the European Institute of Public Administration in this event. I also have with me Michaela Sullivan-Paul, who is our senior research assistant and who is actually driving the discussion on AI in EIPA. She's designing and delivering trainings on the topic, and she will be moderating the 3 segments I was mentioning before. And then we also have Leila Debiasi, who is our digital policy intern, who throughout the question Michaela will have with our distinguished speakers, Leila will monitor the Q&A section. In this sense, you are welcome to submit your questions at any time, and Leila will select those questions from the audience and direct them to the panelists. Now, if you would like a specific panelist to answer to your question, please mention also the name of the panelist so that it is clear for us. As you can see, you have 2 functions there. You have the Q&A function and also the chat function. We would prefer you to ask the question in the Q&A function. And in the chat, if you want to introduce yourself and to tell us where are you joining from what country, from what organization, please do that in the chat. Now, I'm turning to our distinguished guests and speakers today. I would like, first of all, to thank them for taking the time from their very busy schedule to be with us today and to discuss about the topic of cooperation and coordination across the EU AI governance actors. First, I would like to introduce Mrs. Sonia Perez Romero, who is the head of unit of the Artificial Intelligence Unit at the European Data Protection Supervisor in Brussels. She is also the head of the Office of the Secretary General, and before that, she was a legal officer at the Policy and Consultation Unit, where she advised on data protection in the banking and finance sector, but also in the e-health sector. And her previous experience includes working in the Single Resolution Board, which is an EU agency for those of you who don't know, but probably you do, in the financial private sector, and previously in the law firm Hogan Lovells, where she was an associate lawyer in the litigation and arbitration department. In addition, she's a qualified lawyer in Spain and also in the New York State, and she holds several degrees and a master in European Legal Studies from College of Europe and an LLM in International and American Law from Columbia University in New York. We are really grateful to have you here, Sonia, with us, and we are looking forward to hear your insights on the topic. Thank you so much.
Thank you very much.
And we have also Stefan Kalk with us, who works as a coordinating advisor at the Department for the Coordination of Algorithmic Oversight, short DCA, where he's involved in the development of supervision under the AI Act. Now, this department, as I mentioned in my introduction, this department called Department for the Coordination of Algorithmic Oversight is a separate organizational unit set up within the Dutch Data Protection Authority. And Stefan previously worked as a researcher and associate professor at Utrecht University and invited professor at Erasmus University in Rotterdam in the field of law and technology. He was particularly interested in and researching the digital platforms and their roles in the digital age, so a very good connection with the AI topic of today, and has also designed and delivered courses on data protection and coordinated a master program on law and technology in Europe. Thank you very much, Stefan, for joining us, and we are really looking forward to listen to your insights on how the Dutch Data Protection Authority and specifically this unit, organizational unit within, is working with the other stakeholders. And then we have also our third speaker, to whom we are really grateful that she joined us from Croatia today, Ana Maria Mladinic. She's the head of the sector for EU International Cooperation and Legal Affairs at the Croatian Data Protection Authority, and she brings over a decade of experience in the field of data protection. Also, since 2024, Ana Maria was elected Vice Chair of the Committee of Convention 108 of the Council of Europe. Those of us working the data protection, again, we know that it's the oldest international organization dedicated to the protection of human rights, which unites 46 member states from the broader European region. And she actively contributes to the work of the European Data Protection Board, which probably is an organization that we will speak about today, and serves as the project manager of the R2 project, whose flagship outcome is Olivia, which is a web-based tool designed to support small and medium enterprises in achieving data protection compliance or GDPR compliance. And currently, and this is the link to the topic of today, she focuses on the interplay between data protection and the artificial intelligence, identifying privacy risks throughout the life cycle of AI systems, and she provides actionable guidance to Croatian AI providers and AI deployers. Thank you very much, Ana Maria, for joining us.
Thank you, Florina.
We are really happy to have you here. And without further ado, I will give the floor to Michaela to start the discussion on the first segment of the panel of today. Thank you, Michaela.
Thank you so much, Florina, for those opening remarks. And once again, thank you so much to our distinguished panel of guests for joining us today on this very important topic. As mentioned, we have 3 segments of this panel discussion. And so I'd love to go ahead and get started with our first segment of the discussion, which really centers around defining roles and the responsibilities of these key AI governance actors here in Europe. So to initiate this conversation, Sonia, I turn to you. The EU digital regulatory framework really establishes a network of AI governance actors. We have market surveillance authorities, we have national public authorities, notifying authorities, and of course, our data protection authorities. Each are tasked with a very specific function in this larger project that is effective and trustworthy AI governance. So as the EU's independent supervisory authority for data protection, but now also the surveillance and notifying authority for all European institutions, bodies, and agencies under the AI Act, the EDPS plays a critical role in AI governance. So from your perspective, how should these respective roles and responsibilities of all of these authorities, all of these actors, how can they be clearly defined and delineated, particularly where mandates regarding AI, data protection, but then also fundamental rights and cybersecurity may overlap? And what role can the EDPS play in helping shape this delineation, especially to ensure clarity in areas where data protection intersects with these, broader AI governance roles? Thank you.
Thank you, Mihaela, for the question and for having the European Data Protection Supervisor represented today in this workshop. Indeed, the AI Act is a complex infrastructure of institutions with multiple actors that have different mandates, but that all of them intersect at a certain point. We consider that this complexity is a challenge, but this is also a strength, as it ensures a comprehensive oversight and coordinates the different actors. We have, for example, Article 74.8 that states a clear role for data protection authorities or equivalent independent authorities for a certain areas such as migration and law enforcement affairs. We have Article 77, which determines the involvement of fundamental rights authorities when there are specific cases that intersect with their mandates. In the case of the EDPS, our list of fundamental rights authorities under Article 77 includes ourselves, the EDPS in the unit of the data protection, so as data protection authority, but also the ombudsman or the authority for political parties and political foundations, which is also affected by this. We also have law enforcement authorities with whom we collaborate within the subgroup of the AI board on the specific field. So as you see, it is a multitude of actors, but this multitude of actors ensures a comprehensive framework for everybody. At the EDPS, we've been preparing for our role since even before the adoption of the AI Act, and this is why institutionally we decided to create two different units, two different structures to deal with the two different legal bases that are together under the person of the supervisor. We have, as I said, the data protection units, where the enforcement of data protection is led by the supervision and enforcement unit. And we have the AI unit, which is the market surveillance authority, and develops also the roles of notifying and notified body. Apart from our internal reorganization and the creation of new structures, we have also initiated what we call the AI Correspondence Network, which is a network for collaboration with other institutions in order to ensure that governance is strong enough across the institutional landscape and that we have people in charge of this particular file and that it's not fragmented, but there is a person really responsible for that. Your question was very pertinent. How can we delineate competencies and responsibilities? Well, I think that there are three fundamental elements for that. First, there must be institutional clarity on core competencies. Internally, the organizations and externally, the citizens need to know who is in charge of what. This is one of the reasons why the supervisor decided to create the AI unit in order to for the citizens and for the institutions to understand when we are acting as market surveillance authority and when we are acting as data protection authority, and to create really a separation of roles that then go together and the same person, the supervisor. So this helps clarity in our scope. This also requires an analysis of cooperation. So the second element for the delineation of responsibilities would be a formalized cooperation mechanism. We need to have MOUs that determine how Article 77 authorities will interact with the market surveillance authorities, how data protection authorities in the specific fields of migration and law enforcement and justice will coordinate with market surveillance authorities. There are many places where we interact, and there needs to be a formalized coordination mechanism. Now, we are already working on this. It is not that this has been left without analysis. We have the AI board subgroups, And in the AI award subgroups, there are already specific areas that are being tackled in subgroup, and they will be at the end of this year a specific subgroup on markets cooperation and an ADCO group hosted in DigiGrow, the Commission, to cooperate with other products, because we cannot forget that we talk about AI, but AI systems are products. So there are also other authorities that are in charge of product with whom we also need to coordinate. The third element for the delineation of responsibilities would be the mutual recognition of decisions in order to avoid contradictory guidance, because that could really undermine compliance. We have established already a very good recognition of decisions in the data protection framework, but we now need them in the framework of the AI Act. And in this sense, I would call the attention in particular to a provision of the AI Act affecting the EDPS. We have Article 101D that says that when the EDPS will establish a fine or a penalty based on the breach of the AI Act, it needs to also consider those penalties for the same facts under other regulation, meaning we have GDPR or EUDPR in our case that will apply at the same time than the AI Act. And there can be an AI system that processes personal data, so that there are two different infringements based on the same AI system. In there, we need to see how the penalties will apply in order not to have the principle of non-bis in idem, not to fine for the same fact. I think that the EDPS can contribute to the delineation of competencies by sharing our own experience, how we are analyzing the process of when we need to act under one hat or the other. And I think that also, rather than addressing AI in silos, that the success of the AI Act will depend upon the collaboration of all authorities at different levels, but also supranational, because AI systems are not now only a national concern. AI systems normally will go supranational, so there will be not only a collaboration of the different sector authorities, but also these sector authorities with the same sector authorities in the European member states.
Thank you so much, Sonia. You're already starting off the conversation with 3 actionable kind of recommendations. We have institutional competencies and clarifying this, but we also have formalized cooperation mechanisms and mutual recognition. So starting off the conversation very strong with these actionable recommendations. But I'd love to pull our fellow panelists into the conversation. So Stefan, I'm going to turn to you and kind of pose the next question. So as we know at this point, the AI Act really places a strong emphasis on fundamental rights. We know this through various articles in the EU AI Act. And yet the responsibility for assessing and mitigating these risks is really distributed across a wide range of actors, really throughout the entire life cycle of these AI systems. So this includes developers, but deployers, national public authorities, market surveillance authorities, when applicable. And so from your perspective then, how can it be ensured that the responsibilities for assessing and mitigating fundamental rights risks are clearly and appropriately kind of allocated within this very nuanced framework of AI oversight, and really ensure that we're not just kind of passing the ball of responsibility between these different actors, but really ensuring that we have consistency throughout, again, the AI life cycle with regards to fundamental rights?
Thank you, Michaela, for the question, and thank you also for having me here today. I think, as Sonia has already pointed out, and I think what you also stressed, Michaela, I think that the supervision of AI will be a shared responsibility among different supervisory authorities, and I think the AI Act applies in general. It's a horizontal law. Still, it cuts through different kinds of sectors that all have their own dynamics, different actors I think that the use of AI in the courtroom by judges to maybe support decision making is very different from AI being used to allocate energy. Likewise, AI in financial services is very different from biometrics. So I think what is key is that so there's also some value, I guess, maybe in a sectoral approach, in taking in sectoral insights and these dynamics into our supervision. So there's some value to it maybe as well, that we make these distinctions. However, as you point out, having consistent supervision is also very, very important, and to make sure that fundamental rights are properly protected, we need to coordinate at the national level, at multiple levels. But I'm working with the Dutch DPA, so my focus now is on the national level in particular, and we need to cooperate as supervisory authorities and just share also the experiences that we have with fundamental rights. And working with the DPA, it's no surprise that, well, we are very happy that DPAs will have a role to play here. They have expertise here. At the same time, this is a different role, as Sonja also pointed out. This is it's a different ballgame, market surveillance. There's links to the GDPR, but it's a different way of supervision, requires a different mentality also, I think. But still, I think as DPAs, we have a basis, we have an expertise that we can build on in this landscape of supervisory authorities, and we can really be of help to other authorities as well. So in the Netherlands, the Dutch Data Protection is appointed as a coordinating supervisory authority already. So a lot of work that we do relates to setting up a governance system together with other authorities, where we collaborate, where we also advise Dutch government, for instance, about how to implement the AI Act. And having this structure, setting up this structure where as authorities we can connect, discuss and collaborate and take decisions together, that is really important. On the side, I think what is also very important are these informal interactions that we have as supervisory authorities. So we all, because of course we have you can have a formal governance nationally and also at the EU level through the AI board. But I think these informal exchanges between authorities are just as important to make sure that consistent for consistent application of the AI Act. Something that we do maybe a bit on top of AI Act supervision. We're not appointed yet, but we hope to be appointed. But something that we are doing next to the AI Act is that we monitor the risks of AI use and the developments in Dutch society more generally, and we report on that every 6 months in a risk report. And there we also cooperate with other supervisory authorities and inform policymakers and also the general public. And that way, that is also, I think, a good instrument. Monitoring, collaborating, sharing what we see as authorities is also a good way to support the market surveillance activities that we need to conduct as well. So yeah, to summarize my answer, I think it's which is maybe a bit similar to what Sonja has already said. Collaboration is very important. Governance is really, really important. And I think it's also important that is recognized as a task for supervisory authorities. Yeah? In this digital age, you see that a lot of new EU laws coming in, so we cannot work in silos anymore. We need to cooperate, collaborate, coordinate, and that has become a supervisory task as well. And that also means that we need funding for that. So we're not, as supervisory authorities, we're not just supervising, but we need to collaborate, to coordinate as well. And I think that's an important new task and something that we also need to learn, that we're working on as authorities. Thank you.
Thank you so much, Stefan. I think Yeah, I think in terms of resources, you make a really important point, not just on kind of the profiles and the skills that are needed by these teams, but also the resources that are available for them to be able to actually carry out these surveillance duties and responsibilities. I also like the comment you made about kind of these different applications, touching on different sectors, and really a call for kind of these dynamic mechanisms for being able to assess things like fundamental rights and other impacts as well. So a really interesting point that I look forward to kind of unpacking throughout this conversation. I do want to stay on this topic of fundamental rights briefly as well as I move on to Anna Marie. So we've mentioned various articles, but specifically Article 27 of the EU AI Act, which is what introduces the requirement for these fundamental right impact assessments, specifically for these high-risk AI systems. And from what we understand, the interpretation is that these are designed to complement the existing data protection impact assessments that were introduced in the GDPR. But there have been some concerns that have been raised that in practice, providers and deployers might focus potentially disproportionately on data protection when conducting such assessments, and maybe kind of parse over some other fundamental rights that may receive maybe less attention in the process. So this raises not only kind of methodological questions about these assessments, but also institutional ones, which we've touched on already about kind of institutional competencies and roles as well. So I'm curious from your perspective, how do you see responsibilities in being able to perform and review these fundamental rights impact assessments? How should they be allocated over different oversight bodies, especially in cases where the DPA is also a market surveillance authority? And in your experience, kind of what features would you like to see or conditions would you like to see to help ensure that these fundamental right impact assessments are carried out without any unnecessary maybe duplications or redundancies with other existing frameworks?
Thank you, Michaela, for these excellent questions. I will just start with a brief overview of the situation in Croatia, because situation in Croatia is completely different than in Netherlands and in EDPS. So in Croatia, we still did not appoint oversight bodies within the meaning of Article 70 of AI Act. So at this point of time, makes a little bit difficult for me to say how responsibilities for reviewing fundamental rights impact assessments should be allocated between authorities, because we still don't know which authority or authorities might take on market surveillance role and notifying role and all others oversight roles. One thing is certain, that we in Croatian Data Protection Authority don't have enough resources to become a supervisory authority under the AI Act, and due to very low salaries, for example, just last week 3 employees resigned. So we don't have not even one single expert. We only have 2 IT experts who are experts in cybersecurity, not in AI. So we are already struggling with the existing tasks under the GDPR. And given the situation, it is very unlikely that the Croatian DPA will be appointed as a market surveillance body. But the truth is that in Croatia, no authority has necessary expertise and capacity to take on this responsibility. The main reason is the huge salary gap, a really huge salary gap between the public and private sector. For example, an average lawyer in Croatian DPA earns 1,400 euros, while in private sector can earn double or even more. So it is hard to imagine that AI expert or IT expert or any kind of expert would like to work for this kind of salary. Some regulators like competition authorities, Croatian National Bank, telecommunications regulator have more resources, but they have no knowledge on fundamental rights and freedoms, on data protection. They don't have any experiences in assessing impact of data processing on fundamental rights and freedoms, which we in Croatian DPA have. And I must say that enforcement of AI Act I see as a huge, huge challenge for Croatia. As for our DPA, even without becoming market surveillance body, we still have this our supervising role we need to supervise processing activities in AI systems under GDPR. This will also be a major challenge for us. As I said, we don't have any resources. And I don't see any hope that this will change in the future. As I said, the salaries are so small that simply people don't want to work in Croatia DPA because it is not enough to survive, literally. So at this moment, to be realistic, we don't see ourselves in a position to review or guide fundamental rights impact assessments because of a lack of knowledge in fundamental rights and freedoms, IT knowledge, AI knowledge, and so on. But times have always been very difficult for us in Croatian DPA. I have been working in Croatian DPA for more than 10 years. And when I arrived, my salary was 200 euros. Now it's 2,000 euros. So it is better. It can change for better. And we hope that it will change. It will change in the future. Our AI providers and AI deployers turn to us for advice because we are only authority in Croatia which offers advice and carries out workshops for SMEs, for AI developers and AI providers. And we try to there's 5 people in the agency who is able to learn about these topics. So we try to gain new knowledge and to transfer this knowledge to our AI providers and AI developers, because in Croatia we are a small country, underdeveloped country, but we have around 500 AI developers, and they are quite worried about AI Act. So since we don't have our own knowledge, we have engaged with expert Professor Alessandro Mantelero, who developed together with Catalan Data Protection Authority very exhaustive, comprehensive methodology for carrying out fundamental rights impact assessment. Catalan Data Protection Authority has implemented this methodology in its work, and I'm aware that European Commission is developing its own guidelines on this fundamental rights impact assessment. But our developers are asking from us help now, and we believe that this methodology is very good starting point. If you want, if you're not familiar with it, I can share this methodology with you. It was presented last week at the Spring Conference of European Data Protection Authorities, and the feedback is very, very positive. So having all this in mind, I again need to emphasize the importance of data protection impact assessment. So controllers who intend to carry out personal data processing likely to result in a high risk to rights and freedoms of individuals, they need to perform data protection impact assessment. And in the case of AI systems, according to opinion of Croatian DPA, it will always be the case, and we will always require in relation to processing of personal data in AI systems, data protection impact assessment. In the event that both fundamental rights impact assessment and data protection impact assessment should be performed, it is, in our opinion, recommended to combine these two analyses to have them complement each other. So the data protection impact assessment will be carried out first by the provider and subsequently by the deployer. And then fundamental rights impact assessment can then contain the elements not yet covered by the performed data protection impact assessment. So definitely recommend to start with data protection impact assessment and then to integrate it into a fundamental rights impact assessment. So it is again important to highlight that fundamental rights impact assessment only applies to the deployment phase of the high AI risk system, while data protection impact assessment must be conducted during the development stage before processing of personal data. So there is one use case that we have from our Croatian practice. For example, we have AI-powered tool for cancer detection. We would ask from the provider who developed the tool data protection impact assessment. We developed template with the questions about the lawful basis, data principles, source of data, how data subject can exercise their rights, and so on, about technical and organizational measures. and the deployer needs to again carry out data protection impact assessment before using this AI system. So the scope of fundamental right impacts assessment is much wider. In fundamental rights impact assessment, we are assessing impact of whole AI system, not only processing of personal data, but of whole AI system on fundamental rights, included not data-related rights, like freedom of expression, or discrimination, access to service, right to physical and mental health. While in data protection impact assessment, we are assessing risks to rights and freedoms of individuals arising from processing of personal data. So this is this main difference of these two assessments, where we, in fundamental rights impact assessment, we need to take into account whole AI system and all fundamental rights, and you can see from this how this is comprehensive, and then you really need to have experts in the field, not only AI field, technical field, but also in the field of fundamental rights and freedoms. So, for example, in this case of AI tool for cancer detection, one of the risk is incorrect functioning of the algorithm that may result in ineffective and harmful medical treatment for the patient, resulting in a prejudice to the right to health. Then, in this case, severity needs to be calculated, likelihood needs to be calculated, overall impact then needs to be calculated and identified, appropriate mitigation measures, and then those measures needs to be implemented. To be able to do this, such a comprehensive assessment, deep knowledge in fundamental rights is needed, and deep knowledge in medicine, deep knowledge in technology is needed. So you need a whole wide range of experts to carry out such comprehensive fundamental rights impact assessment. But also, I will conclude with this, it's important to say, I have carried out a few trainings for our Croatian AI Association, and all developers there are very worried about fundamental rights impact assessment. It is important that this obligation applies only to deployers that are bodies governed by public law, private entities providing public service, then some banking and insurance service providers, as listed in Article 5.BSC of Annex 3 of the AI Act, and in the case when real-time remote biometric identification in public accessible spaces is used. So it is not obligatory for all AI providers. It is not obligatory for all AI deployers. It is obligatory for certain groups of AI deployers.
Absolutely. Thank you so much for providing those clarifications. And indeed, we are familiar with the Catalonian Fundamental Rights Impact Assessment, and look forward to seeing kind of how these frameworks and these guidelines kind of advance over time, especially we all await eagerly that of the European Commission's guidelines. So with that, I do want to conclude on the first segment and move very quickly to the second segment, which is really about overcoming challenges in AI oversight and enforcement. And so Anna Maria already kind of alluded to some of the challenges that they're facing at the Croatian Data Protection Authority. But I'd like to maybe shift a little bit to kind of some of the proactive ways in that, you know, some administrations are already addressing some of these challenges. And so I will turn back to Anna Maria in asking, you know, given your role at the Croatian Data Protection Agency, you've seen firsthand some of the kind of administrative burdens that can affect compliance and innovation with regards to artificial intelligence. And to respond to these challenges, you've participated in projects like ARC2 and Olivia as kind of these innovative ways to address some of these challenges. And so I was hoping you could very briefly share some of a little bit more about these projects and these tools that your institution is developing to help reduce these administrative burdens. And also maybe talk a little bit about how your initiative and how the community is responding to these types of tools. Bearing in mind that we are running a little bit behind time, so I'm going to ask that we please stick very strictly to our 4 to 5 minute time limit for the next following segment. Thank you so much.
Yeah, the first question was very comprehensive. The second one is not, so I'm not planning to talk a lot about the second question. So at the level of European Union, it was recognized that SMEs are struggling the most with understanding their GDPR obligations and complying with the data protection legal framework. We received, we don't receive it anymore, but previously we were receiving on daily basis a lot of questions from our SMEs on how to comply with GDPR, and that's why we decided to develop a very practical tool funded by European Union that will help SMEs to generate privacy policies, legitimate interest assessments, and like data protection impact assessments. Very practical tool where you are answering to some questions, and then Olivia generates templates, generates these assessments. Because there are a lot of guidelines and guidance, but our SMEs don't read it. They don't have time, they don't have skills, they don't have knowledge, and they need something very practical. So literally they need some templates where they're going to enter text, and then the system generates according to their answers these various GDPR, as they say, GDPR compliance papers. In addition to this, there are a lot of webinars, very short, because our SMEs don't have time, don't have willingness to watch long, complicated videos about GDPR. We need to be aware that we are professionals and we have willingness to listen to this, but they don't have time, they don't have willingness. And so short webinars, this generator of GDPR compliance papers, and this is something that it is very, very useful for them. At the end, they can test their knowledge, and they can fill out quizzes. And if they have enough answers, then Olivia will generate confirmation of completion. This is something that they really like and use. In Croatia, the feedback is amazing. We have like 15,000 of SMEs using it, which is for Croatia really very, very, very great figures. And we are now planning to add on Olivia AI models. So models about assessing risks, models on fundamental rights impact assessment, something very useful and practical, because AI providers are not lawyers. AI providers in Croatia are small startups, like guys fresh from the college. They don't have money to hire expensive lawyers. And we are here to support innovation, although we also need support, and we are like literally in very bad circumstances, but we are offering them practical support, practical solutions, and try to help them to find solution to develop their AI system models in line with the GDPR, and in the future in line with the AI.
Thank you so much for sharing. Indeed, they're very impressive projects, and so I hope that they act as kind of an example to other administrations of how they can be proactive in helping support communities when it comes to compliance, not with just the AI Act, but also with the GDPR and other EU law as well. Stefan, pardon me, I want to kind of, from your perspective, we've heard some of the challenges that the Croatian DPA is experiencing, but I'd love to hear a little bit from your perspective, some of the challenges your institution is facing with regards to AI, kind of implementing the AI Act, and ensuring kind of compliance with it, and perhaps if there are any kind of best practices you've encountered thus far that can help kind of mitigate some of these challenges. I'd love to hear your thoughts as well.
Yeah, so I think one major challenge with the AI Act is that the timelines and deadlines are very, very short, and also that I don't think in the Netherlands we'll have market surveillance authorities appointed in time. And I think this will be the case in several member states. Still, we are sort of ready to go, and we want to try and support AI Act implementation where we can, and we've been doing quite a lot already. So we have worked on guidance on how to promote AI literacy. We've also done a few calls for input on the prohibitions and to see what Dutch market players, how they interpret the prohibitions and what challenges they face as they are confronted with the AI Act. But still, we haven't been appointed yet, and I don't think we'll be appointed in time, which creates a little bit of tension in the sense that we really want to do things. We want to support innovation, also, of course, keep in mind and protect fundamental rights and make sure that the prohibitions are respected, but we're not yet in a position to do so, and that is a difficult position to be in. Hopefully, this will be resolved at some point, but that makes it difficult for us to operate. And of course, it's not. This is a democratic decision in the end. So it's not. I'm not blaming anyone, just to be sure. But this is, I think, the consequence of the AI Act and the short deadlines and the time. And it's very complex legislation and the time that it takes to fully implement it. I think a challenge also that we see is, and that we can definitely face is or overcome, is that we need to be able to exchange information between the authorities. So we really need to have also a legal basis to share information with other authorities. You can imagine that information about cases can be sensitive. So I think we also need an infrastructure to do that in a correct manner. And also, we are a data protection authority. We hope to be assigned as a market surveillance authority. But yeah, the AI Act is not like the Digital Services Sector, the Data Governance Act, or the Data Act, where maybe you, in your role as a data protection authority, can have an added value, or there are rules that are very close to the GDPR, or maybe even a lex specialis to the GDPR. I think with the AI Act, it's as I mentioned before, it's a very it's a different ball game. The way in which you supervise is very different. We have to rely on standards that are not there yet, which is another challenge. And also, we as a DPA, we're not used to that kind of supervision. So that is also something that, well, it's not a legal challenge, but this is a challenge that we have, is that we need to adapt a bit as well as an authority, and also getting different expertise, and also think very thoroughly about how we can combine the role of a data protection authority and a market surveillance authority, where you may be a bit more dependent on what the European Commission is saying, whereas in the GDPR side of things, we are very independent. So there's also some challenges also on how to institutionalize this new supervisory role within the data protection authority. And then, yeah, as I mentioned, the standards. And I think we of course, you probably know that for high risk AI, we need standard, or it would be very helpful if there are standards by the time that these rules start applying. And yeah, I think this is a challenge that we not only face ourselves as an authority, but that market players face as well, and society as a whole. So I think we need to be creative here and trying to find solutions, and also maybe as an authority be a bit patient with respect to market parties. And I think there's still a lot of questions of how to apply the AI Act. What is an AI system? Of course, we have there's a European Commission guidelines, but what do they mean in a practical, concrete situation? So there's a lot of questions still to be answered, and I think we really should try to do that together as surveillance authorities, but also as market players. I think we need to make it work together for society. But I think the AI Act in that sense is still a work in progress. Yeah, it's been published, but there's still a lot of work to be done. Yeah.
I think you're certainly right, Stefan. And I do want to just pick up a little bit on what you're saying, and I think has been kind of a consistent theme in this discussion, which is that of the profiles of these individuals or these teams that are really tasked with overseeing AI kind of compliance and responsible AI development and deployment. And so I moved to Sonia with a question. So as administrations, companies, all of these kind of different players begin preparing for the AI Act implementation, we're seeing emerging roles, whether it's AI officer, AI compliance officer, or through the EDPS, these AI correspondents, they're being designated within institutions, within companies, within firms, tasked with this immense, responsibility of supporting internal compliance and coordination. And unlike, data protection officers whose responsibilities are really clearly defined and delineated under the GDPR, these AI roles, they really lack kind of a formal legal mandate, which often leads to questions about the scope and the accountability and the interaction that these actors would have with other governance functions. This raises really, important considerations for institutional clarity, as you've already mentioned, especially with complex administrative structures within EU institutions, which I know you're familiar with. So from your perspective, what challenges does this kind of lack of a prescribed function present for these AI roles, and how might the EDPS help clarify and support the definition of these profiles without kind of blurring the lines and duplicating mandates between different governance actors?
Thank you very much for this question, Michaela. Indeed, let me start by saying that the EDPS has always put an emphasis in the fact that the AI correspondent, it's a non-regulator or a role not foreseen in the AI Act. This was a proposal by the EDPS in September last year, which was triggered, let me say, by two concerns or issues that my colleagues in the panel have raised today. The first one of them is the lack of resources in public administration. We need to do with what we have, and that's an important caveat to know when we are developing the AI Act. The second one is the fast deadlines of the AI Act. We need to, the public administration doesn't move that as fast as the private sector. Our budgetary estimations go from one year to the other. So if you need someone right now, you probably will need to wait until the next year's budget is in place. So these two important concerns came to the table of the Secretary General here in the EDPS, and then by some coincidence we met the head of the now eliminated US AI Institute, Elizabeth Kelly. And in that conversation, one of our questions was, how do you ensure that the governance of public bodies in the US is strong enough? And then she pointed to the person of the AI officer, AI chief officer, which was a person designated in the Biden executive order, with the responsibilities of indeed taking care of AI compliance in American public bodies. And that was her strength in order to get to all the public administration. So we leverage from that conversation. We also leverage from our very good experience with the Data Protection Officers Network. You know that there is a DPO network by the DPA, steered by the EDPS, in which we collaborate. And then we propose a concept note in September 2024, in which we presented our concept of AI correspondent. This person for us would be a person that would be in between the operational level and the management level. A person that would be in the change of management, in the chain of management, not in the change, so that when there is a decision making relating to AI governance, this person would be able to advise, but to advise from a very practical view, from the very good knowledge of the operational side, and of course, with their expertise in AI. This was our proposal, and then we left it open as to what profile would have, because as you know, the ecosystem of European Union institutions is very diverse. So we've had a very good welcoming of this idea. And I am happy to say that out of the 78 institutions, agencies, and bodies, all of them have appointed an AII correspondent now. These AII correspondents do not have the same profile. Some of them are DPOs. Some of them are IT heads. Some of them are legal officers. Some of them are procurement. Some of them are compliance. So we have very different skills, depending, of course, on the profile, because if you have a large-scale system that you need to oversee, you have a specific structure in your organization. But if your agency or body is in charge of procuring grants, then maybe your AI systems go more into a different set of machines. So the profile was open. I would say we have more or less 1/3 DPOs, more or less 1/3 IT/engineers, 1/3 legal at the moment, but the network is working very well. The welcoming, as I said, was very good. Also, one of our concerns was that the emerging AII correspondent role would not undermine or duplicate the DPO. I think we've also managed to clarify this. DPOs are in charge of all personal data processing. AI systems are broader than the machines that process personal data. But what we've also made very clear is that DPO and AI correspondent need to work very closely, because it's a very closely related matter. And we consider that the risk of an AI governance fragmented could also impact the institution. So we think that the liaison between the AI correspondent with the compliance functions and with the DPOs is essential, at the same time that he is dealing with the two levels of management decision making and the operational side. How we help institutions address the challenges of the AI correspondent and its not regulated post. Well, we think that this discussion in September really helped institutions to know who was their person, but we continue to have at least 2 meetings per year with the AI correspondence community, where we work on what should be the objectives of this network, what would be the profile. On top of that, in order to make sure that the high rank hierarchy in EU institutions are also involved and aware, once per year, the EDPS Secretary General meets at the level of Secretaries General with EU institutions, and they kind of discuss what would be the objectives for the year of the network, for us then to roll out and to tell AI correspondents that their hierarchy has somehow blessed our program for the year, and that the projects we are working are already pre-approved by their top management. This also helps to have a top-down approach to the working year, and then to give empowerment to these AI correspondents, because this is an empowerment that they need to obtain directly from their top management, as there is not a provision in the AI Act that would foresee such role.
Thank you so much, Sonia. I think with that concludes our second segment of this discussion, which leaves us our third one and our final one for the panel discussion, where we'll be talking more about strengthening cooperation and effective AI governance, which again has also been a common thread throughout this conversation. Before we do that, I just want to kindly remind everyone to please take an opportunity to post your questions using the Q&A function. I really hope we'll have enough time to be able to answer some of the audience questions in the final segment of this panel discussion. But I'll go ahead and get started with the third one, and I'm going to go right back to you, Sonia, with a question here. You mentioned kind of the ability to be able to learn lessons from other administrations of what's working, best practices, what's not working necessarily. And with this in mind, I mean, we've had kind of cross-border cases under this kind of one-stop shop mechanism in the GDPR. And I think it's been helpful in highlighting some of the difficulties we might encounter when coordinating enforcement across different member states. So I'm curious, given the EDPS's role as a member of the EDPB, but also its broader involvement in AI oversight, can we use this kind of one-stop shop, this experience with it to help kind of leverage lessons learned when it comes to AI coordination across member states? Any lessons from cross-border GDPR enforcement that can really be applied now, but also to future AI cases as well?
Thank you very much, Michaela, for this question. Regarding enforcement coordination, I think it is going to be crucial for moving from implementation to enforcement. We've talked about the different stakeholders, and we've also talked about the different structures within the EDPS, the AI unit, and the supervision and enforcement unit for data protection that need to collaborate together. Our supervisor unavoidably wears two hats interchangeably, and for that's the establishment of a clear communication about what mandate he's enforcing at each time would be absolutely necessary. You put me questions about whether the coordination challenges will be similar to the GDPR one-stop shop. I would say that the AI Act does not establish a formal one-stop shop mechanism precisely because AI systems are and will be per se cross-border. Their cross-border nature will inevitably create coordination challenge. But despite not having a one-stop shop, I think we can kind of hint to three lessons learned from this type of GDPR enforcement. First one would be an effective information sharing system. This is essential from day one. Under the GDPR, the establishment of information sharing systems took some time, but now we have this 2-year period until the AI Act becomes fully applicable. And I think it's an opportunity for all authorities involved to create a robust information exchange system that allows us to work. We've talked about Article 77 and how fundamental rights agencies will be involved, but now we need to know in practice what does it mean and what circumstances are they able to request the assistance of the MSA to obtain documents. What would be the scope, what would be the assessment? So that's, I would say, the first element that we can draw a lesson from. The second one would be procedural alignment. Procedural alignment matters as much as substantive alignment. So we need the same procedural approaches across authorities in order not to create friction. And this procedural alignment is being worked as we speak in the subgroups of the AA board. We are sharing practices about how we would go, for example, about penalties, which is a procedure that needs to be in place by August 2025, when the deadline to appoint an MSA for the AA Act also applies. So we are talking about how we will go about the analysis of high risk. We will have guidelines from the Commission in February 2026 on high risk. So we need to align on these procedural issues so that the frictions are less and less when we go into the enforcement. And then we need to also work on resource asymmetries between authorities, because AI Act needs resources and we need experts. And bearing in mind that we will need to work very much cross-border and with other authorities, we need to find also that the counterpart is effectively and sufficiently resourced in order to cooperate together. Otherwise, the cooperation just will fail just for the lack of means. So I think the resource asymmetries needs to be addressed by member states as well. There is already cooperation, as you may have heard, in between the authorities for the AA Act and the Authority for Data Protection. There is a close cooperation as we speak on the guidelines for the interplay between AI Act and GDPR. The EDPB is closely cooperating with with the DigiConnect, and I am convinced that we will get guidelines that will be very good and that will align the concerns from both areas and specifically in their interplay when there are cases that are blurry or gray, so that the citizens and the industry, which is applying the AI Act, will have clarity on what to do and what is exactly what they need to pay attention. Let me just close this question by saying that by ensuring that the AI Act principles are embedded in AI development, I think that we're helping the citizens and the industry to build systems that are trustworthy, and the trust is what makes democracies strong. So it is very important that we go to AI by design and AI trust by design, so that in the future our world is strong from a democratic point of view and safe for everybody.
Absolutely. Thank you so much, Sonia, for that. I'm going to move over to Stefan now. I mean, we've heard throughout this conversation kind of really the need for better communication, for knowledge sharing amongst different AI communities. I think as a community ourselves, we're getting much better at acknowledging that strong AI governance really starts with an interdisciplinary kind of approach. When it brings on, we're bringing on IT specialists, legal professionals, digital experts into the conversation about AI governance. This can be challenging, I think, at times when it feels like sometimes we're all speaking a different language and we're using, different terms and concepts to explain kind of our common kind of perspectives. So I'm curious from your perspective, how can professionals, maybe those who are even in a similar position to yourself, how can we facilitate collaboration and communication between all of these different AI communities? And how might these insights contribute to shaping maybe more harmonization or kind of interoperability between these different actors when we're thinking about governance structures here in the EU?
That's a great question. So yeah, I can share with you what my experience is sort of in my job here with the DPA, and I think I don't know if this is true for all DPAs, but I think the Dutch DPA is a very sort of an organization that where a lot of lawyers and people with a legal background work, and we have a few technologists, and they're a minority. So what we try to do in our sort of the department that we set up for AI and algorithm regulation is to really get a mix of people in. So unfortunately or fortunately, I'm one of the few lawyers in this department. We have people with a machine learning or data science background, people with the economics background, philosophy, ethics. So we really have a mixed group of people, and I think that is what it all starts with: getting these people together in one group and having them communicate with each other, and that creates. It sometimes at first you may find some difficulty to really understand the others. But you just need to start working and doing it together. So one thing that we also do is in our group is to we have weekly meetings and we present our work, and those are really valuable moments because there I get to see what my data science colleagues are working on, and they try to explain me in layman's terms, or at least terms that the lawyer like me can understand. What the issue is with fairness and how difficult it is to capture that. So I really think it's important that you have this interdisciplinarity within your authority and also in your groups. Also, I think also as among authorities. That is very important because so as I mentioned at the beginning, there's a lot of different authorities probably going to be involved in AI Act supervision, and they all bring their own expertise, but also their own culture, and they have already a set mandate which sort of shaped that culture and their way of working. So it's really important also that the authorities we not only collaborate but work with each other. So something that we have been doing quite a lot in the past 2 years is also organize workshops where different authorities can join in, and we discuss cases and try to sort of play with the AI Act a bit already. We're also doing that at the EU level with some authorities already. So that is important as well. So I think it's at least from a supervisory perspective, it's not just the expertise or but also I think the authorities also bring their own cultures, and we need to bring those together as well for the AI Act supervision to make it work. Yeah, maybe as a final point, I think what is also really important, what I always found very strange when I first read the AI Act, that there's no sort of coordinating role necessarily in the AI Act in this supervisory scheme. And of course, there's this principle of subsidiarity, so it's up for the member states to design their institutional setup for supervision. But I really think it's key that you have an authority in your member state that can really take the lead on topics and facilitate also these exchanges that are very, very necessary. And in that sense, we are organizing that at the national level. At the EU level, we're not there yet. We have an AI board, and of course, member states are primarily represented, but we as authorities, or at least we're not appointed yet, but discussions are already going on. Now, the EDPS is in a different position, of course, but that makes it a bit difficult for us to cooperate with our counterparts in the other member states, of which I'm sure they have an even different way of working and culture, and we need to, as Sonja very nicely put, we need alignment there as well, both material and substance and procedure. But at the EU level, we still do not have that platform yet. I hope it will be there soon with the administrative committee that has to be set up. But still, I think also informal meetings and workshops and getting together and working on cases and try to understand each other's language and perspective is very important here as next to this more formal platforms like the AI board. So yeah, that was my end.
Thank you so much, Stefan. Okay, so I still want to make sure we have at least some time to answer maybe one audience question, but I'm going to turn to Anna Maria to kind of conclude with similar remarks, if you could. I mean, you've already kind of alluded, you've mentioned to the challenges that your administration is facing in terms of resources and capacity and adjusting to new roles. But nevertheless, I mean, the Croatian DPA does have a designated role under Article 77, which means that there has some expansion in its responsibilities. And so I was hoping maybe you could kind of conclude our conversation, not maybe just by focusing on the challenges, because those are, I think, clear to us, but perhaps how we can be proactive, how we can overcome some of these challenges when it comes to resource limitations, so that organizations and institutions like yourself can continue carrying out the roles that are appointed to you.
Yeah. So one thing that it is very important, that it was also highlighted by Martin, director of your institute, peer learning. So we have this amazing opportunity within EDPB to learn from more experienced data protection authorities, like, for example, Dutch Data Protection Authority. Just recently, my colleague Marco returned from secondment program from Dutch DPA, and I hope that he learned a lot about AI auditing and algorithm bias. So at this point of time, we have in our authority Norwegian colleague who is going to, we are going to learn from her about regulatory sandboxes, because Norway has a lot of experience in regulatory sandboxes. So this peer learning is very important for us. We also in Croatian Data Protection Authority for last 6 months are undertaking a lot of AI trainings on various topics in AI field. So this is our way how to cope with this situation, to engage with external experts and to engage with our peers, which is very important for us. Also, EDPB is organizing this fall EDPB AI auditing bootcamp. So although these opportunities are great for us to learn from more experienced colleagues. So this is the way how we cope with the situation. And we also, of course, initiated amendment of our national law. And of course, we ask from our government more financial and human resources, and we will see what will happen. But we are always proactive. We never sit and whine. We are always proactive, but I need to whine a little bit. I deserve it. Thank you very much.
Thank you so much, Anna Maria. Indeed, actually, I think one of our participants is working for the Innovation Agency in Lithuania, also working on regulatory AI sandboxes. So who knows, maybe he'll be your next Sakota national expert. Okay, I think that concludes our panel discussion. Like I mentioned, I think it's a really good opportunity for us to interact directly with our audience as well. So with that, I want to thank you so much to our panel for being able to answer these questions that we prepared for you. And I turn the floor over to my colleague Leila, who will be facilitating our interactive Q&A. Thank you so much, Leila.
Thank you, Michaela, and thank you for our speakers for the very engaging conversation so far. We'll now move to the Q&A section. We'll hear from our panelists in regards to questions from the audience. So unfortunately, we don't have much time for a lot of questions, sadly. We would have loved to hear much more about this. But I will go ahead and start maybe with a question addressed to all three of our panelists. So getting into a bit of a hot topic, we know that last week, the European Commission announced the start of a simplification process for the GDPR, which was a very talked about topic in recent weeks. But my question to all three of you is now, looking ahead, do you see any potential impacts on the implementation of the AI Act in light of, especially of the overlap between the two regulations that all three of you have mentioned quite a lot during this panel? So it's very recent news, but do you have any first reactions to how this simplification process might both directly affect the implementation of the AI Act or also potentially prompt further simplification efforts for the AI Act itself? So maybe, Sonia, would you like to start getting into the conversation?
Yeah, sure. Well, I think that we are precisely in the time to speak about how to implement the AI Act because we have not yet gone into the full application of the law. So it is now when we need to figure out how we will see the provisions in practice, how we will cooperate between DPIAs and FRIAs, how we will go about the transparency obligations that apply to general purpose AI systems. So this doesn't mean that the AI Act itself is going to be put in question. We are more into the development of implementing rules that will allow us to live with the new regulation, which is very impactful. So if any, I think this trend for simplification will have a positive impact in the market because people will understand that this is an easy thing to do, that it has always been like that for regulated products. I don't see now producers of toys saying that it is very difficult to comply with the toy regulation or with the medicines to comply with the deadlines for medicines. These are regulated products because these products affect health of the people, and the AI system will also affect the citizens in that way. We cannot forget that the legal basis for the AI Act is Article 114 of the treaty, together with Article 16 for data protection. But 114 is about internal market. So we are just doing a stronger internal market. So it is also good that we have practical implementing rules. And the Commission is working on that, and we are very happy to assist them and to discuss within the context of the AI board subgroups that the EDPS attends.
Thank you so much, Sonia, for your answer. Maybe now a quick reaction from the national authorities. So, Stefan, do you have any considerations about this, followed by Ana Maria?
No, not so many. So maybe for the sake of time, I'll keep it short. I think what Sonia pointed out is very, very true indeed. And of course, we also have to keep in mind that the AI Act itself is probably also a subject of simplification. It's hot off the needle, but we're already maybe changing it. And I can really imagine that there's still some room for, in particular, SMEs, startups, to maybe lower burdens a bit. But this is really, I think, for future discussions. So I'm passing it, I guess, to Ana Maria. Yeah.
I would agree with what Stefan said, and Sonia, I don't have anything to add, anything relevant.
Thank you. So for the sake of time, are we going back to Florina for final remarks? Do we have time for one final question, maybe?
But you have questions in chat, in bot, in chat box, in chat bot. There are questions, you know that? Okay, you
Yeah.
probably know.
And
Okay.
I think I try to limit my closing remarks to 1 to 2 minutes, just to give the participants the chance to ask another question. So Leila, please go ahead with the questions.
Perfect, thank you. So going back to Ana Maria then, we have one question in the chat about specifically this varied nature of authorities that can act as MSA, as Stefan also mentioned quite a lot during his answers. So the question is if you believe this diversity could hinder a harmonized approach to supervision across member states. And I was especially interested in light of the difficulties you mentioned associated with resources, both in terms of knowledge and finances as well. Would you think this additional layer of difficulty brought by the varied nature could hinder a harmonized approach and the consistency of enforcement?
Yes, for sure. Yes, it will hinder, definitely, yeah. So yeah, the answer is yes.
Thank you. Very straightforward.
Yeah, I'm always straightforward.
No, very.
Not good in diplomacy at all.
So maybe one last specific question for Stefan about the Dutch situation specifically. So the Dutch police has been using facial recognition software, such as Catch, for years. And since the Market Surveillance Authority may not be appointed in August, the situation implies that only courts may impose fines from August in case of infringement of the Act, since Article 5 of the regulation has had direct effect since February 2nd. So the fact that only courts, but not the Market Surveillance Authority, may monitor the correct implementation of the AI regulation questions a bit the balance of the system established by the regulation. So what are your considerations about this matter? And you talked also quite a bit about this difficulty in going after approaching deadlines and the difficulty with timelines. So I was very curious to hear your thoughts about this.
Sure, yeah. Just to be sure, I cannot comment on like actual views or cases, but in general, I think it's good to keep in mind that, of course, the AI Act, it's a big AI law in Europe, but we still have other laws in place, especially when you look at the prohibitions. They're very clear red lines that you cannot cross, but of course we still have the GDPR, the Law Enforcement Directive, many other laws in other sectors, also police specific in the Netherlands, that regulate what in this case the police can do or not do with facial recognition systems. And so it's not that I was maybe whining a bit as well, but I think also from a GDPR perspective, we can still, as an authority, be forceful here if necessary. But I agree. I do agree in the sense that it is maybe from the perspective of sort of a PR perspective, it's not very handy to have prohibitions in place that are not be able to be enforced. And that here this doesn't do, I think, the AI Act and supervision much good. But still, there's hope. There's still a lot of other laws and supervision in place that can help to prevent unlawful uses.
Thank you, Stefan, also for reminding us of the complexity that this also entails on various levels. So thanks to our speakers, and thank you for our viewers for the questions. And with this, I pass the floor back to Florina for our concluding remarks.
Yes, thank you very much to all of you, those who participated online with so many questions, and also to our distinguished speakers for taking the time and being here today. What I think I want to say, just one more minute to keep everybody a bit after the time that we were supposed to dedicate to this webinar, is that indeed we have explored that there is a complex landscape of governance, and obviously we can see the good part, and we can see the strength, like Sonia mentioned, and all the three elements that she emphasized on how we can protect fundamental rights, foster innovation, and provide legal certainty through institutional clarity, formalized cooperation mechanism, and mutual recognition of decisions. But then on the other hand, we have seen also the fragmentation and also the challenges, because different data protection authorities, different other stakeholder authorities that will be appointed and that fall under the AI governance are acting in different scenarios, from the lack of resources, lack of budget, here we can see the challenge. And not only that there can be fragmentation because there are so many authorities involved, but also because of this other situation. And I think one thing that I want to conclude with, I really think that what Stefan mentioned about the informal exchange of information is something that we at EIPA are very much doing. And I think that's why, as I said at the beginning, EIPA's role is very important, since we have this expertise from the data protection certification course, where we see a network of DPOs engaging with the new DPOs. And obviously, I know data protection is a different field than the AI, but we see this peer learning and the way that this course and this training and the capacity building that is our mission at EIPA actually shape the conduct and can set standards where there are no standards, like Stefan mentioned. And I think it's really important to mention that, especially for these challenges that Anna Maria, but also Stefan mentioned, because in the Netherlands we still don't know whether the Dutch Data Protection Authority, though it wants really much to be the Market Surveillance Authority, it may not be appointed due to the different reasons. So I think that's what we are dedicated here at EIPA, to actually foster this dialogue, and also to look deeper into this peer learning and how we can build further on our data protection certification course, but also on our AI courses that we are developing and deploying. So again, thank you very much to all of you for being here today. We are really grateful for spending this lunch with you, and hopefully we'll see each other in different environments and fostering dialogue continuously on this topic. So, and thank you also to EIPA team for this hard work to put together the event. Thank you, and have a nice afternoon.